Dr. Iacopino is a recipient of the Center of Victims of Torture Eclipse Award for extraordinary service on behalf of torture survivors and the University of Minnesota Department of Medicine's Distinguished Alumni Award. Welcome, and we're so grateful to have you here.
Thank you, Leva. Thank you. This talk, as Leva said, is about the Istanbul Protocol and its relevance to the clinical asylum evaluations that you conduct here in San Diego. And let's see if we can get this straight. So I understand that many of you are not familiar with the guidance in the Istanbul Protocol. So understanding that, the purpose of this talk is really to generate discussions on your evaluations and not to make you experts in the IP. That takes reading and knowledge and some practice. So before we get started, since this is intended to be a discussion, let's get a sense of people's experiences. A show of hands, how many people here are immigration attorneys? Great. And adjudicators, either asylum officers, raise your hand high, please, or immigration judges. That's one, right? Wonderful, thank you. Clinicians, raise your hand. And keep your hand up if you are a physician and a psychiatrist. A resident in training, medical student, several, psychologist, licensed clinical social worker, and others that I might have missed? Okay. Just the clinicians now. How many of you have conducted 10 evaluations or fewer? Just one. Between 10 and 21. 21 to 50. And more than 50. Great. Who here has heard of the Istanbul Protocol? Yay. And who actually has used it in their clinical evaluations? Great. And you actually refer to it? A few. Okay. How many here have participated in trauma-specific trainings online? Okay. In person? Good. And how about the new asylum medicine training curriculum? Great. We'll talk more about that. And how many have been mentored? Super. All right, that's helpful, to me at least. So what is the Istanbul Protocol? As Leva said, these are UN standards recognized around the world for the effective investigation and documentation of torture and ill treatment, both legal investigations and clinical investigations. At about 1995, when I was working in Turkey, my colleagues were submitting so-called alternative reports, which were very fine evaluations of the alleged torture that they assessed. And those evaluations were denied in court, while at the same time, the official forensic statements were simply no sign of injury or lesion, right? So we had this idea back in 1995 to develop a framework to hold states accountable and to empower physicians and clinicians in civil society. That was really the origin of the idea of the Istanbul Protocol. It was born out of this state's denial of torture and records, forensic records that didn't show the evidence. So we worked for 3 years, 75 of us, from 15 different countries to produce the Istanbul Protocol together with the Office of the High Commissioner for Human Rights, OHCHR. We developed 6 chapters in the original version that OHCHR published in 2001 on legal standards. The legal chapters are 1 and 3, the legal standards and how to conduct legal investigations, relevant ethical codes, both for legal professionals and health professionals in Chapter 2, and then the clinical chapters 4, 5, and 6 on general interview considerations, physical evidence of torture, and psychological evidence of torture. Importantly, there are several annexes. Annex 1 has what are called the Istanbul Protocol principles, or IP principles, that contain the minimum standards for states to follow with regard to clinical evaluations and legal investigations. So it's just a page and a half, right, those principles. And the manual itself, which was about 75 pages, was really an elaboration of those minimum standards, right, how to conduct a legal and clinical evaluation. Let's look at those, at least the clinical provisions in the Istanbul Protocol principles. We're not concerned with the legal provisions right now. We're not conducting legal investigations. They're very simple, and as I said, these are just a half a page. And it requires that clinical evaluators behave ethically and obtain informed consent, that their evaluations conform to established standards, which, by the way, is the manual, and be under the control of the clinical expert, not security personnel, and be conducted promptly. Their written reports need to be accurate and include the following: identification of the alleged victim and conditions of the evaluation, a detailed account of allegations, including torture or ill-treatment methods, and physical and psychological symptoms, a record of physical and psychological findings, interpretation of all findings, an opinion on the possibility of torture and or ill treatment, and clinical recommendations, and finally, identification and signature of the expert. Pretty simple. Well, since 1999, their IP has been recognized as a global standard immediately through the UN and the 4 anti-torture bodies, the UN Committee Against Torture, UN Special Rapporteur on Torture, who was working with us, that was Nigel Rodley at the time, the first UN Special Rapporteur, the UN Subcommittee on the Prevention of Torture, and the UN Voluntary Fund for Victims of Torture. I'm sorry, that's a mistake. Early on, SPT didn't exist until I think it was 2006, so that happened later. Also by regional human rights bodies and regional human rights courts, as well as in national jurisprudence and federal laws. For example, in Mexico, there's a federal law that requires the application of the Istanbul Protocol, at least for their forensic evaluators. And in Colombia, it's required of prosecutors and forensic folks as well. UK Supreme Court case that I testified in 2019 basically established the IP as authoritative guidance for asylum evaluations in the UK. So there have been lots of practical applications of the guidance from medical legal reports in criminal, civil, and administrative, i.e. asylum cases, in human rights investigations and international human rights monitoring, whether it's UN anti-torture bodies or regional human rights anti-torture bodies or national mechanisms and institutions that are trying to combat torture. For advocacy and accountability and prevention, and capacity building, my colleagues and I have worked in many countries since 2001 when the IP was first published, 40 countries or so. And that has morphed into very large implementation projects, which I'll talk about. And sometimes it's used in intake evaluations in rehabilitation. These are some visual slides, images of those examples of applications, individual medical evaluations. Oops, sorry, wrong way. In asylum evaluations, these are 2 individuals who I examined. The gentleman on the right, your right, and on the left suffered the same heavy metal roller being pressed on their bodies. You can see the late effects on the right, a wasting of the muscles, that basically tissue that doesn't regenerate, and fibrosis. Whereas the individual who I examined in Kashmir, he was in dialysis unit because he had such extensive muscle damage, which is toxic to the kidney, that he had acute renal failure. It just shows you, acute versus chronic effects. And we'll talk about how historically you can capture some of that information of what happened acutely, very specific information. As I said, in human rights investigations here, Punjab and Kashmir, Sometimes we have to abbreviate evaluations given the prevailing conditions, the timing, and so forth. Also, in some of our PHRs, large population-based assessments of war crimes and other human rights violations. In assessing prison conditions that are equivalent to ill treatment and torture. There in Cambodia, but in many other countries. And in holding the U.S. accountable for its torture practices, we've examined former detainees to show that they have been tortured, as well as people in Guantanamo. A number of us have gotten our security clearances and have examined individuals there in federal habeas cases and military commission cases. That's Mohamedou Ould Salahi, a gentleman I examined in Guantanamo. You may know him from his New York Times best-selling book, Guantanamo Diaries, or the movie The Mauritanian, which features Jodie Foster, Tahir Rahim, Shailene Woodley, others, Benedict Cumberbatch, etc. You should watch it if you haven't seen it. Also, you know, when states use unnecessary and excessive force, that is tantamount to ill treatment and torture here after the Gezi Park protests in 2013 in Turkey, but also in the United States and many other countries. We've looked at child separation at the US-Mexico border. Okay, so over the past 30 years, we've conducted lots of trainings on the Istanbul Protocol for people in civil society, state officials, human rights bodies, and so forth. Here's a list of many of them. UN anti-torture bodies, national preventative mechanisms, prosecutors for the International Criminal Court. We did a training for forensic judges in Chile with the reopening of the Pinochet cases. Some of those people have been convicted in Supreme Court. The Ukraine prosecutors came to us for IP trainings when they were starting to evaluate cases of torture. Similarly, with the recent protests in Iran, clinicians there came to us for trainings, et cetera, et cetera. And as I said before, some of our trainings have been very long-term, over a period of 8 years, where we've tried to actually establish the conditions necessary for effective documentation of torture. Very involved, and they're called implementation projects. Some of the training materials that we've developed over the years, a model curriculum, a very large document that was developed before this new edition of the IP. It's very useful and slightly out of date. Many country-specific materials that we've used to train people in the countries I've mentioned. And this new asylum medicine training curriculum, which we'll talk more about, that's available online. Okay, so we updated the IP. It was published in 2002. It was a 6-year effort. It was a mammoth effort. I was once again in the lead of that project. We were 180 clinicians, legal experts, human rights experts from 51 countries. It was coordinated by 4 NGOs, PHR, the IRCT in Denmark, Human Rights Foundation Turkey and Redress, as well as the 4 UN anti-torture bodies. We updated over a 6-year period, and we identified updates through a process of 3 regional stakeholder meetings, and we actually conducted a survey of more than 200 IP users. I've included a bunch of URLs here for you. Soti will be providing a copy of this PowerPoint to everyone today, and so you can peruse the IP itself. If you're interested in what exactly has changed, there's a PowerPoint and some other materials as well. All right, let's look at the changes. The 6 original chapters, all of them were updated. You know, certain things were clarified. There's new guidance in all of those chapters. We'll talk a little bit about that. And there's 2 new chapters. They're not relevant for today, but Chapter 7 is about the role of health professionals in documenting torture and ill treatment in non-legal settings. That doesn't apply to you. Asylum is a legal setting. And also implementation, as I said, these conditions that are necessary for effective documentation. Let's go back just a second. Annex 2 has changed. It was all about diagnostic imaging, and now it's about children. We have lots of new guidance on children throughout the document, and it's all summarized in Annex 2. Annex 1, the IP principles, hasn't changed, right? And also Annex 4, which we'll talk about, the guidelines for your evaluations, that hasn't changed either. All right, so what's important for asylum evaluators? I think the clarification on the definition and scope of torture. You see many cases of these forms of ill treatment or torture. Chapter 1 enumerates them. This is also in ORR's language. Basically, extracustodial uses of force, as we mentioned, in peaceful protests, gender-based violence, many forms of that, as you can see, violence based on sexual orientation and gender identity, abusive healthcare practices. So chapter 2 is about ethics, right? And there are many updates for legal and health professionals. Basically, there are 4 relevant ethical principles that health professionals need to be concerned about. Most importantly, for asylum evaluators, obtaining informed consent, and that is consent that's comprehensible, disclosure of all material information, including the purpose of the evaluation, potential risks and benefits, the nature of the evaluation, including the possibility of taking photographs, limits on confidentiality, and any mandatory reporting requirements. Kids have to be consented as well these days, in addition to their parents. They'll need to have the opportunity for that. And just a word about beneficence in the context of asylum evaluations. Your objectivity and credibility are extremely important, not only to the individual applicant who you're evaluating, but to survivors of torture in general. So you never compromise your objectivity and credibility before the court, because that undermines your obligation of beneficence to survivors of torture. Does that make sense? Chapters 3, 7, and 8 are not particularly important today. 3 is on legal investigations of torture. There's lots of new guidance there. 7 and 8, I've already summarized what they're about, so we're going to skip that. We're going to focus on chapters 4, 5, and 6, the interview considerations, physical evidence, and psychological evidence, respectively. Okay? Each of those chapters includes updates on the physical and psychological effects of torture and ill treatment, as well as guidance on how to interview and conduct clinical evaluations of physical and psychological evidence, including new guidance on evaluations of children and of lesbian, gay, bisexual, transgender, and intersex persons. So we're not going to talk about this today, but it's really great guidance that you should look at, and it actually connects to what we are going to talk about, which is the post-interview considerations, interpretation of findings, conclusions, how to assess self-infliction, credibility, et cetera, et cetera. And I'm going to give you some recommendations of how to do that, but of course they depend on how well you conduct your evaluation in the first place. Okay, so chapter 4, this is regarding, oops, did I skip a slide? Yeah. So chapter 4 talks about interpretation of findings, as do the other chapters. Basically, an interpretation is required as to the probable relationship between each physical finding, or in the case of your psychological evaluation, all of the psych findings, and the possibility of torture and ill treatment as defined in the UN Convention Against Torture, right? It doesn't make sense to correlate individual psychological symptoms with the possibility of torture. And the level of consistencies that we use are not consistent with, highly consistent with, typical of, and diagnostic of. For psychological evaluations, typical of is not very meaningful because those are individual experiences, and usually the evidence doesn't rise to the level of diagnostic of. I have an aversion to diagnostic of in the first place. We'll talk about that. And regarding conclusions and recommendations, the IP requires a clinical opinion on the overall possibility of torture and ill treatment, considering all relevant clinical evidence, including, so it's not just your physical and psychological findings, it's also historical information, photographic findings, whether they're contemporaneous to the events or your photographs, diagnostic test results, knowledge of regional practices, consultations, etc. Causation is expressed in terms of consistency rather than judicial standards of proof. This is to avoid conflation with clinical opinions from judges. And a conclusion on all of the clinical evidence should be based on the highest level of consistency reported in your evaluation or the combined evaluations. I know you don't do them together. Some people here may do combined evaluations. You really should use the highest level of consistency. And in some cases, the overall evaluation can report a higher level of consistency than each individual finding of consistency, right? So if everything in, let's say, your physical evaluation is consistent, and so forth, you might come up with highly consistent with some other factors. In kids, you need to apply relevant standards, which usually have lower thresholds, especially when they're detained. Regarding self-infliction and simulation, these should always be viewed in light of all of the symptoms, right? The clinical presentation, not just one element of it. And if you suspect it, you should document and obtain a second opinion. You do not have a duty to consider those possibilities in the absence of an evidentiary foundation. That may sound strange to you, but it happens in a lot of countries. You know, some other prisoner did this, you know, they slipped and fell down the stairs, etc. So asylum judges and officers appreciate statements on the possibility of malingering. And over the years, the idea of credibility has come up in many different ways. The IP finally has guidance on this issue of credibility. Clinicians have no business talking about credibility. I used to talk about it sometimes, and then we had the big training with EOIR, the Executive Office for Immigration Review in DC years ago. And basically, what we do have to offer is our assessments of the reliability of clinical evidence based on elements of internal and external consistency. I'll go into that in detail in a second. And lastly here, I mean, many countries have weaponized the IP and their misunderstanding about its utility. The IP is a tool that basically allows people to document torture. It's helpful in detecting torture, but it doesn't exclude the possibility. If you don't have physical and psychological evidence, there might be lots of reasons for that, right? The physical evidence may have disappeared or not been, you know, of the type to leave lasting marks. The psychological evidence can be mitigated by various factors and so forth. Okay, these are the elements of internal consistency, the corroboration of elements in an individual's case. I'll read them, there are many, but important. The consistency between the descriptions of physical injuries and reports of subsequent acute symptoms, the healing process, and chronic symptoms and disabilities, right? I'm going to show you a slide that relates to this in a second. The level of consistency between specific allegations of abuse and documentation of physical and psychological findings, that's obvious. Congruency between an alleged victim's observed affect, their emotional state during the interview, and the content of the evaluation. When you're talking about shame and humiliation and so forth, there are emotional reactions that evaluators, whether you're physical or psychological, can document, okay? The temporal relationship between the alleged abuse and the onset of psychological symptoms. That's important. How do you distinguish between PTSD from the alleged trauma versus the flight experience or previous traumatic experiences and so forth? The temporal relationship is helpful. Fluctuations in psychological symptoms in relation to internal and external psychological stressors and mitigating factors. I think the psychologist will know about that. And the congruency between an individual's emotions, both reported and observed, and the individual's coping mechanisms. Also, the individual meaning assigned to the alleged abuse in light of the individual's psychosocial history. I can give you examples of that. And also there are PTSD symptoms that can specifically refer to the alleged trauma, like the content of nightmares, triggers for intrusive recollections and reliving experience, as well as avoidance thoughts and behaviors. For external consistency, this is all about the allegations of torture comporting with regional methods of torture, maybe the body positions that were used. And in some cases in Punjab, where I saw lots of Sikhs in San Francisco, I saw the same torture descriptions of torture devices and so forth. Also witness testimony, medical reports, prior photographs, etc. Those are external consistency factors. Yes, so these are all acute signs of torture, contusions of muscles after leg stretching, these tram lines that are characteristic of beatings with a police baton. And you see this facial droop. The person has a right facial droop. There was trauma, not in this individual, this is a stock photo, but in cases I've examined, I've heard histories of people who are beaten to the face. The facial nerve exits right out here by your ear, and when there's swelling here, it compromises the nerve, and it can give you a temporary Bell's palsy, a facial droop. And documenting this kind of historical information is really very helpful because it's highly suggestive or corroborates the allegations of torture that are being alleged. So I use this religiously. I mean, think about it. You're examining people months, years after the evaluation. You can capture some of that contemporaneous evidence through a really good history. Okay, let's look at Annex 4, which hasn't changed. Basically, this is an outline of what your evaluations are supposed to look like, but the IP is not a fixed protocol, right? It's meant to be guidance that informs your evaluation. Let's understand that as we go through it. There's relevant case information, your qualifications, a statement about veracity, because after all, this is information that's reported to you. It's hearsay. Some attorneys may argue. And you give the background information. There are subcategories for some of these, like allegations of torture and ill treatment. That's a long narrative usually. And then the red is for physical evidence evaluators. You ask about physical symptoms and disabilities, conduct your physical examination. Blue refers to a psychological evaluation. So this is presumably one evaluator doing the whole evaluation. And there are various categories here of information to collect. I can say that in my psych evaluations, I didn't follow this exactly, but in general. And I'll say a word about psychological testing. It's optional. I hope that people don't simply use psychological tests and offer a diagnosis or not and its level of severity. They can be helpful, but it doesn't really tell the story of that particular individual. And neuropsych assessments, I think, are rare. They're rare because we don't have psychologists who do them, and it's usually not necessary to distinguish between the effects of PTSD versus traumatic brain injury. Either way, they're alleged to be from the same traumatic experience. Are you hearing me okay? Yeah? Okay. Photographs and diagnostic test results for physical evidence clinicians, and then your consultations, interpretation of physical and psychological findings, your conclusions, etc. So I thought it might be helpful. We had a number of discussions about affidavits and what evaluations look like here and so forth, and the time pressures that people are under. I'm offering some suggestions. This is what I did for my evaluations for the interpretation of findings and conclusions. So this is me now. It's sort of the best advice I can give, or at least what I used to do when I was conducting evals. So for the physical evidence, I would list each of the physical findings and the level of consistency for each finding as the IP requires. I did not use typical of or diagnostic of. I generally would use virtually diagnostic of, because on cross-examination sometimes people will say, look, this is a legal determination, torture. It has to be by state officials and for a particular purpose and so forth, and your evaluation doesn't cover that. So I narrowed my evaluations down to highly, these levels of consistency. Okay, these days I might use typical of, but it doesn't work for psychological evaluations. And this was before the new guidance. So I never felt comfortable using typical of. So this is sort of a license that you can use your own good judgment and defend it in court, right? Comment on the consistency between the history of the acute and chronic physical symptoms and disabilities with the allegations of abuse. We just talked about this with the tram lines and so forth. You may have just a couple of garden variety laceration scars, contusion scars, and so forth. And when you have this kind of historical information, your conclusion may bump up from consistent to highly consistent. And also the external corroboration from the methods of torture, etc., that we mentioned. Regarding psychological findings, I list the psychological findings as symptoms and relevant diagnoses, levels of severity, and then, as the IP requires, give a level of consistency for all of the psychological findings with the sum total of allegations of abuse, right? And I then include elements of internal consistency, as we discussed, onset of psychological symptoms, the fluctuations over time, so all that temporal stuff, congruency of affect and the specific content of the interview, and some of these, let's say, cause-specific symptoms within the complex of PTSD. So it's also helpful, and I used to comment on the factors that can adversely affect perceptions of the applicant's credibility, their affect, their demeanor, their cognitive function, particularly memory, and potential causes of that, and then the extent to which the applicant's social functioning has been compromised. I think we'll hear about this shortly, that judges do like to hear about the possibility of malingering, and I used to offer a statement about the reliability of the clinical evidence, things like the applicant answered all questions in a straightforward manner, there was no evidence of defensive or suspicious behavior, or over-endorsement of physical and psychological symptoms, and again, the affect congruency and so forth. I think these are really helpful things for judges, at least to know that you think those things. Conclusions, my conclusions followed the IP, a statement on overall consistency, which you can see with my levels of consistency, a reiteration of the symptoms and disabilities that a person may continue to suffer from, and any recommendations for further care. Okay, so what does this mean here in San Diego for your evaluations? The IP is this great thing, it's a global standard and so forth. How relevant is it in asylum evaluations in our location here? It's not required by US law. It's not routinely applied in clinical evaluations, and immigration judges and asylum officers, I don't think they are aware of it by and large, okay? However, I think that evaluations that use the IP can make a difference. Now, PHR has had an asylum program for 30 years, and they have been training people with the IP standards, and they keep track of their the outcome of asylum evaluations from their network. And there have been two surveys, one in 2008 and one in 2021, that have shown that grant rates were much higher with a clinical evaluation from a PHR evaluator than the national average. In 2008, it was 90 versus 38%. In 21, it was 82 versus 42%. So I'm inferring from that that the IP is helpful. There's a little study that I just came across in 22 of 9 immigration judges who served in 12 jurisdictions. This is a very small number and so forth, but they were asked about their perceptions of telephonic and in-person evaluations, mental health evaluations, and I think it's insightful. We have one former immigration judge here. I'm hoping we can discuss this further. They revealed that some of their preferences to have a formatted, readable evaluation. I usually use paragraph numbers and subheadings and so forth. Provide evidence to support whatever conclusions you have. Include a malingering assessment. Avoid advocacy and legal language like don't talk about credibility. Don't refer to the applicant or an alleged victim as a survivor or a victim. Those are judicial determinations. You're in the wrong lane if you're using them. And to detail your qualifications. They consider the role of your affidavit, at least the mental health affidavits, as providing evidence and explaining manifestations of trauma. And regarding virtual versus in-person evaluations, they viewed both positively and related in-person as stronger, but no surprise there. They had concerns about telephonic, but they thought that it was better than no evaluation, and especially if you disclose the modality and explain why you're using it. All right, at this point, let's talk about the pros and cons. These are some that I wrote down for this presentation. I'm sure we can think of more. I think the IP can be a means of ensuring quality and accuracy of clinical evaluations and consistency across the board. It can aid in qualifying an expert, especially a new expert, and improve adjudication outcomes by enhancing the credibility of the clinical evaluation and the expert witness, identifying elements of internal and external consistency, enhancing clinical explanations of factors that can affect credibility, demeanor, affect, cognitive abilities. And also, if you're going to work in other settings, like in criminal cases, in human rights investigations and so forth, the IP is more commonly applied. Considering the cons, obviously, if you're not familiar, you need to acquire some knowledge. The pages for chapters 4, 5, and 6 are listed here. It's not terribly onerous, maybe 50 pages for a physical evaluator or psychological evaluator. And it may increase the length of your evaluations if they're short, right? If they're maybe 4 pages, 6 pages, it might increase it by a couple of pages. We can talk about that. Judges are really busy, right? And we don't want to burden them with the kinds of evaluations that I used to conduct. And you'll see example affidavits of where they're 15 pages, 20 pages, and so forth. That was a different time, and I think we need to focus our energies and distill our evaluations to what's really essential and not miss out on anything, right? I think that can be done. I know, working with attorneys for many years, that any additional detail is considered a liability for credibility and so forth. That can be mitigated by coordination, reading evaluations, both reading one another's work so that you can see whether or not there's inconsistencies. And I guess there's a possibility of, once people start using the IP, creating a judicial expectation. Why does this person not apply the IP and this person is, and so forth? And lastly, my concern of clinicians just simply gratuitously saying they use the IP when they're not, and undermining its overall value. Quickly, time check, Safi?
You have 10 minutes.
10 minutes, oh good. I'll just say a few words about how to, get trained and what's going on with PHR. I mentioned they've had this silent program for a long time. Currently, they have 2,000 pro bono volunteer clinicians. They annually facilitate more than 700 evaluations. I checked on the stats for California just a week ago, and there are currently 264 clinicians in California who work with PHR. Just a handful in San Diego. And in 23, there were 106 evaluations, 14 in San Diego. At present, there are 22 open cases in California, 7 are in San Diego, and there are 11 cases that are open outside of San Diego that interested clinicians can conduct remotely. Should you be interested, you could contact them. PHR has partnered with a number of medical school clinics that conduct asylum evaluations. They're eager to partner with more. I know there's some interest here in San Diego. And they offer asylum trainings in person less frequently now, since we have very good online trainings. I mentioned the asylum medicine training introductory curriculum before. It's a comprehensive course. It's a national collaboration, over 80 experts from 40 institutions. I never looked at it until just before this presentation, like a week ago. I looked at all of the modules, all of the resources, and I really think it's great. They actually waited until the IP was done to justify their work product with the new version of the IP, and there's lots of references to the 22 edition of the IP. So there are 5 core training modules, as you can see here, and it's more than what's in the IP, like affidavit writing and testifying in court, for example. And then 6 focused modules I think are really helpful. I was very impressed with the traumatic brain injury, the vicarious trauma, and so forth. These are wonderful resources, and each of the modules comes with supplemental material. and videos that I found, wonderful. So check it out. The PHR's website also has a number of resources for evaluators. You can see the list here. I'll highlight that they have sample affidavits. Again, me doing this presentation prompted a discussion about adding more sample affidavits to the website. There are only 2 right now, and we've already collected maybe 10 or so. And so we're in the process of actually expanding that, because I think one of the best ways to improve your evaluations is to look at others. I mean, my evaluations improved over time, and when I've seen some of my high-level colleagues' evaluations, I've picked up some of their licks and so forth, and they mine. So it's a very useful process to be involved in, and nothing to be ashamed of if you're improving your evaluation. Okay. Okay. I think in summary, the IP is important. I think it's relevant. I think we all need to do the best evaluations we can. Survivors deserve that. What you're doing is extremely important as a part of the healing process and the process of justice for people who have suffered horrible experiences. I would recommend that if you're not familiar with the IP, to read the relevant chapters and annexes 4, 5, and 6, and annexes 1 and 4. Consider taking the asylum course, either just reading it or becoming certified. You can add that to your CV. Access additional training materials that SOTI has to offer, and PHR has as well. And then work together and try to improve your evaluations. I think this is the beginning of a discussion that we're going to have for the panel and onward. And lastly, this is not easy work. We all know about secondary trauma and burnout and so forth. I think it's important to work in a supportive community and to learn to take care of yourself and one another. Thanks very much.